so I think we'll go ahead and get started. So good afternoon, everybody. Thank you very much for joining us this afternoon. It's really lovely that you've taken time out of your day to join us for a 1-hour webinar on Tribal Customary Adoption 2.0, 10 years later. I'm really excited to be doing this webinar because CTFC has done a couple of webinars and sessions about tribal customary adoption kind of generally, and tribal customary adoption as it interfaces with resource family approval. But every time we do one of those, questions come up about, well, you know, what about a TCA that's a little bit older? What about these issues that are coming up now that tribal customary adoptions are 10 years on? And so I'm really excited to present this to you all today. Just a couple of opening things. Number one, I'm going to introduce myself, and then we do have a special guest today, and I'm going to just wait a little bit before I introduce him. Housekeeping, we are recording today, and the reason that we do that is that we really like to upload these webinars to allow other folks who weren't able to join us, say, live today, to be able to get the content. So this is being recorded. Number two, in order to be able to move through the material in an hour, what we ask folks to do is please use the chat for any questions. I will try to pay attention to the chat and try to jump in and answer questions as we go along. But if I don't get to a question, please feel free to reach out to me directly. I'm more than happy to answer questions as much as I possibly can, and in a way that we can still get through this material, but get you an answer that for your question specifically. And so again, today, the topic is Tribal Customary Adoption 2.0. So I am going to spend a little bit of time just doing a look back. It's always important with TCA and so many things that we do in Indian law to just take a look back and figure out how we got here. And so I'm going to start with doing a little bit of that. And if you want more of that background on TCA that you haven't gotten, if you've got questions more about some of the basics, then please feel free to oh, we've got some people still in the waiting room. I'm going to go ahead and admit them. Okay, so my welcome I've already stated, and I also just want to do a land acknowledgement. I'm coming to you from Ojai, California, which is a Chumash land, and I just want to acknowledge really the state of California and thank all of the tribes for allowing us to be here. And it is a gorgeous day here in Ojai, and I just really want to acknowledge and state my gratitude for this beautiful Chumash land where I am. So my name is Kimberly Cluff. I'm a California attorney. I've spent my career doing Indian law with a large focus on Indian child welfare. And the audience for this webinar is really anybody who's got questions about TCA. But again, as I mentioned, this is a little bit more of looking past the fundamentals and basics of how to do a TCA, a little bit more on problem solving, TCAs that have already happened, or maybe ways to avoid problems down the road. So CTFC is a nonprofit here in California. Our mission is to promote and protect the health, safety, and welfare of tribal children and families. We strongly believe that doing so is an inherent tribal government function, and truly protecting the next generation is an exercise of sovereignty. We're the successor organization to the task force, and anybody who is unfamiliar with the ICWA Compliant Task Force report, you can go to CTFC's website and download a copy. I strongly encourage you to do that if you haven't already. Okay. Sorry, having a little, oh, there we go. So we are going to do a little bit of what is TCA and how do we get here, and then talk about kind of early and current TCAs, a little bit about TCAO collaboration and development today in our current situation, because it is a little bit more challenging in the land of COVID, and then issues with TCAs and TCAOs over time. Okay, now I want to introduce our special guest, which is John Sobel. but I'm just going to quickly, we know the purposes of ICWA passed in 1978. One thing that's important to remember is that TCA is actually not a function of ICWA. Only children eligible for the coverage in the Indian Child Welfare Act are eligible for a TCA, but California Tribal Customary Adoption came into being long after the federal ICWA and came into being. And in fact, even after SB 678, which sometimes we call California ICWA. Why do we continue to talk about best practice in ICWA? Because we still have tremendous disproportionality. And you can see some of those numbers there. And we use those numbers a lot to really paint the picture of why it is that we've got to continue to work on ICWA compliance in California. We simply haven't lived up to the promise of the Indian Child Welfare Act. And so we continue to work on ways in which we can improve ICWA compliance, ways in which we can change law to protect Indian families better, and also to be flexible. The world continues to move along, and so figuring out ways to continue to be agile in the current circumstances, it's really, really important. Okay, so why tribal customary adoption? Why did this come into being? And I really like this quote. I think it really speaks to kind of that vision of why TCA was developed and what tribal leaders passed on to us when we were working on this. So you can read that quote, but really it comes down to the idea of adoption was and is very much culturally acceptable within most tribes. It's the termination of parental rights that's so problematic. So the idea of making relatives, the way it's been explained to me, is very common and in fact embraced because there's not, for example, the concept of a very fixed nuclear family. Lots of people can be involved in the raising of a child, but the necessary precursor under United States law of terminating parental rights, that was what was so problematic, continues to be really offensive to tribal norms, customs, and worldview. So the practice of mainstream adoption also became an especially problematic concept because, quite honestly, it was used as one of the tools of the genocide. It was used for forced assimilation. And so in thinking about TCA, the concept was we needed to be in line with broader concepts of permanency and stability for kids, but avoid at all costs that necessary precursor of TPR. So how and why did we get to TCA? So I wanted to get a little bit of an inside perspective. And so I've asked John Sobel to join us today. And John was kind of my partner in crime when we were working on this bill. John was serving as, and I think I had it not quite right, but anyways, John was serving as chief of staff for California Assemblyman Paul Cook when the Saboba Band of Liseño Indians approached Assemblyman Cook's office and said, hey, we'd really like to do something about developing a bill to create tribal customary adoption. And John jumped on right away. It was, I think, one of his first pieces of legislation related to tribes, actually, or close to it. And then Assemblyman Cook was elected to Congress, and John followed him to DC. And then John has now joined Jenner Block in DC as a senior government relations specialist. And so I want to turn it over to John and just ask John to maybe give us a little bit of the backstory of your experience in moving this legislation forward and kind of what it meant to you and why Assemblyman Cook and his office supported it.
Thanks, Kimberly. And yes, I was the primary legislative staffer for the initial tribal customary adoption bill, which established the law all the way back. We started in 2008. I'm now in DC. I have to go salt the sidewalk later for snow, so I'm missing my home state. But I want to talk a little bit about some of the challenges that we faced because I think some of them are still illustrative. Unfortunately, they're still illustrative 10 years later. The first thing that we needed to overcome, anything dealing with a tribal issue, particularly a cultural tribal issue, is we wanted to make sure that it was a bipartisan effort. So we found a very willing partner in a gentleman named Jim Bell out of Santa Clara, who was chair of the Health and Human Services Committee. So he was a great partner and gave us gave us a tremendous credibility. The next challenge was overcoming what I call the philosophical opposition. And it was highlighted at the time by the family law section of the state bar, though not exclusive to them. And I remember their written opposition to that initial bill, which stated that they were concerned, and I quote, that it would permit an Indian tribe, custodian, parent, or extended family member to disrupt an adoptive placement. And why was that offensive? Well, that was the whole point of the bill. The whole point of the bill was to disrupt that normal normal process. And they continued and said that the bill would be entire or contrary to the entire statutory scheme. And again, that it started saying to me that, you know, we have a real we have an education issue and we have a philosophical problem here. In fairness, the Assembly Judiciary Committee was willing to work with us to address reasonable concerns. But again, that philosophical opposition spoke to something larger. And to me, it was the idea that American governments, whether it's state or federal, that they know best when it comes to the welfare of a tribe or a tribal member. And that furthermore, that they discount the importance of tribal cultural practices, and they discount the tribe's ability to function as a government. And that skepticism, that a tribe's ability to function as a government, that's a bias that I've seen repeated time and time again in the intervening 12 years since we started this effort. The last challenge, humorous in retrospect, was actually overcoming some of the skepticism of other tribes. And Kimberly Cluff here, obviously, and Nancy Curry, both of whom were with Saboba at the time, they worked, I think, day and night to overcome that. And a lot of what I heard on the Sacramento side was, well, what's Saboba really up to here? What are they doing? Are they trying to pull something? And I think that spoke to the sometimes fractious nature of tribal relations with other tribes. But again, we were able to push through that. So, you know, in the larger sense, I think to me, the bill demonstrated that too many people still refuse to recognize the standing and sovereignty of tribal governments, or as I call it, history through the lens of the U.S. Cavalry. And I hesitate to say that, but I think it's still true. I hear it here in DC all the time. You know, why are we treating them differently? Well, we know that in most cases, tribes are simply asking to be treated equally with other governments. But the unique thing here with this bill is that it gave us an opportunity to have to do something that was historically appropriate but seemingly contradictory, and that was to treat a tribe as an equal government, or at least moving in that direction. California still obviously does not treat them as equals, but also celebrated the differences, which is in this case is the cultural practice. And it also had an immediate positive effect on real people. So I would say I would close it on a personal note. You know, in my 18 years of working in elected office, it was exceedingly rare to see the outcome of my efforts. Usually you're passing a law and it goes out into the universe and you don't know whether it ruined stuff. You don't know whether it helped. You just never see the outcome. But I remember distinctly the following year being able to meet a young person who had benefited from this new law. And while I was not in the line of work as a staffer for an elected official for personal fulfillment, I can't tell you how fulfilling and special that was. And so for that reason, and just for the general subject, legal subject itself, it remains the highlight of my career in legislation. And it was an absolute privilege to be involved. So with that, I'll turn it over.
Oh, thanks, John. Well, I appreciate that. And I thank you very much for joining us today. And I understand you've got other things going on. So if you can't stay, we understand. But of course, we'd love to have you continue on with us. So, listening to John's, kind of perspective and I do want to point out, as a staffer for a Republican member of the Assembly and then in Congress, which, sometimes we think, there's a partisan issue here. But I remember clearly Assemblyman Cook speaking incredibly eloquently at one of the hearings in Sacramento. He had been a high school history teacher very early in his career. And it was just really a joy to hear the really passionate sense that he brought to this work. So it was just great. It was really great. And the bipartisanness was important. Part of the reason that I had wanted John to join us is that I think it's just really helpful to remember that bigger umbrella of how it is that we got here, because sometimes it informs, where we came from. It informs where we're going and informs some of the issues that we come up against. So I wanted to just back up to the real benefits that TCA brought to the table. These motivated us to draft this bill and move it through. So one of them we've talked about already. TCA is more consistent with cultural practices than TPR. The other is that giving a middle ground option between guardianship and conventional adoption, what the idea was that it would help alleviate some of the battles that tribes found themselves in when a tribe is advancing guardianship and a county or another party is advancing a TPR conventional adoption. It gave a middle ground. And that was important because at the time, lots of tribes were spending a lot of resources battling to get to guardianship, not so much because they were avoiding the idea or they were opposed to a child going to other relatives mostly, but someone else, that making relatives process, that was okay. It was the TPR that was problematic. And then the other piece of TCA that was really important and was beneficial is it allows children to continue to receive the basket of benefits that go with a adoption, for example, AAP, as opposed to when a kiddo remains in a guardianship and they're eligible for kin gap. And those benefits, those funding streams are not equal. For example, the main one that I've been informed, the main difference between them is as a child gets older, if they have some mental health issues, if they have substance abuse issues, that the AAP funding, it's only available through an adoption, is a much better funding stream and has more flexibility and brings more resources to a family who's trying to figure out a way to support the kiddo that they've got. I'm going to just quickly ask everybody who's on the line to mute their phone. It'd be really great. Thanks. Okay, so we've got to just talk a moment about TCA and this concept of like, how do we separate out the role of being a parent? The reason that's important is that when we get to the concept of the TCAO, the Tribal Customary Adoption Order, which spell check turns into taco, which is fine with me because I like tacos, but it's kind of funny. It's a little bit of a quirk. So you'll see that I sometimes use the word taco for a TCAO, Tribal Customary Adoption Order. So when we think about parenting, we think about the responsibilities and the obligations of parenting. We generally think that the biological family, let's say a mom and dad, they've got that whole puzzle of parenting. They get all the pieces. They get to make all the decisions. They get to decide what school, they get to decide who visits a child. They get to decide cultural practices, make medical decisions, where to live, all those pieces that go into parenting. So when a child needs care from someone other than biological parents, sometimes we have to take those puzzle pieces and separate them out. And some of them will remain with the biological parents, and then others will go to an alternative caregiver. And that's really important in thinking about TCA, because the concept of TCA is that we're not cutting biological parents off completely. And so it allows some of those puzzle pieces to remain with the biological parents if that's what the TCAO says, that's what's best for the kid. So we've got different types of placements, and I get the question frequently, well, is a tribal customary adoption more like a conventional adoption or more like a guardianship? And I'm just going to give you the very basics of the difference and how TCA is kind of in the middle. The main way that it is like a conventional adoption is that it is permanent. It does not have the ability to be undone like a guardianship with, like in California, a 388 petition, which is a pretty simple petition that goes before a judge. It's more like a guardianship because it has this puzzle piece separating of rights, obligations, and duties, and the tribe has control over what that looks like. Now that control is part of why we're doing this webinar today, because some problems can come with that. Because a plan for a child at 2 years old might be very different when that child is 12 years old for how we separate out those puzzle pieces. So the definition of a customary adoption, it's an agency adoption by and through tribal customs, traditions, or laws of that child's tribe. And it transfers the custody of the child to the care, protection, and adoptive parent, but without TPR. And it is only a function of state court dependency cases where the child is an Indian child. All right, so TCA is no longer a spring chicken. I used to talk about how TCA was this new thing, and it's really no longer new. It's 10 years old. So it was first an idea, then a draft bill, then a law, but it had not been done before. Now, when we started working on this, we leaned heavily on looking to where this concept was being done. And the White Earth Tribe with, now Judge Anita Fine was very much working towards this model, but that was an internal tribal model. We knew, especially as a public law 280 state, we knew as a state with lots of state court ICWA cases where we have lots of parents who veto a transfer to tribal court, unfortunately, that we had to do something that was within or a function of the state court. We knew that there were the customs of making relatives, but we didn't have a combination process. So once the bill was chaptered, there was a rush to get everybody to implement the law. And that didn't go really that great, to be honest. The California Judicial Council did develop forms, and CDSS, the California Department of Social Services, was to promulgate regulations. But still, confusion started and unfortunately continues. But 10 years later, we've learned a lot more about how TCA is used and what it looks like. Because, you can write a bill all day long. As John kind of mentioned, you write a bill and you send it out into the universe. You don't always know what's going to happen. And so what we have realized is that we need to take another look and maybe refine some of what's going on. In addition, other laws have come into play that affect TCA. For example, the resource family approval process, and that intersection is sometimes bumpy as well. So the basic steps of a TCA, inquiry to the tribe. Hey, tribe, this is one of your cases, bring that in. Do you want TCA to be concurrent plan? There needs to be collaboration. There has to be inclusion of a permanent plan of TCA in every court report, beginning with jurisdiction or the jurisdiction disposition hearing. There's got to be a home study, and that's a whole other topic. There needs to be the TCAO that has to be prepared by the tribe. You cannot do a TCA without tribal involvement. It is legally and virtually impossible. There's got to be all the irregular adoptive placement work, and then there's finalization. So that path looks a little bit like this. So what you see in the yellow bricks, detention, JD, this is the course of a regular dependency case. And then there's this little sidestep, which is where the case goes into what I call suspended animation. I sometimes joke it kind of goes into a little suspended bubble. That bubble goes over to the tribe. The tribe does the TCAO. It does whatever practice it is that it does culturally to affirm that the adoption is taking place or the making of relatives is taking place. And then it comes back over to the state. Now keep in mind, that is not a transfer of jurisdiction. Jurisdiction remains with the state court. You might say, well, why? Part of the reason that the process was drafted that way is because we wanted to avoid the possibility that a parent, a non-tribal parent, usually it's a non-tribal parent who would veto transfer of jurisdiction. So this gets around a potential transfer or a potential veto of jurisdiction transferring to the court. And then the case continues on after the TCAO comes back into state court. Now, what has to be in that TCAO? There are required components, basically 5 required components. And I go into a lot more detail on the 5 required components under state law in some of our other webinars. So if you've got questions about the required components, and maybe if you want to see a model TCAO, I strongly recommend you look at some of the other content on the California Tribal Families Coalition YouTube channel, which you can link to through the website. Okay, so a quick snapshot of TCA 10 years later. So there's been approximately oh goodness, I wrote none. There's been approximately I apologize, 9 appellate cases that have come out. Now, one of the keys with those 9 appellate cases, TCA as a form of placement has been held up every time. So when we first went out into the appellate courts early on, we thought, okay, let's see if this will stand up to the scrutiny of the appellate courts. Maybe it will be struck down. Maybe there'll be a problem. Some of the first cases, you can see the names of them there, In Re HR, which is a very important case, In Re AM and In Re IP. The most recent is a case called In Re AS, and that was from 2018. I have a quote down there at the bottom from the In Re HR case, and I think that this quote really, for me, kind of tells the story of where we are with the validity of TCA. The court said this was a challenge to TCA as a permanent plan. Absent some evidence of a countervailing detriment to the minor, so absent somebody being able to say TCA would be bad for this kiddo, the court in its discretion concludes, the court concludes would be because of a TCA. So if somebody presents evidence to the judge and the court can logically say, that evidence tells me TCA would be bad for this kid, barring that, TCA is the first alternative for a permanent plan for a kid. Now, this can be a little problematic because there's no question some tribes prefer to remain with a guardianship as their permanent plan, and that's tricky. It's tricky because what we've heard sometimes is that counties will use TCA against a tribe and say, well, we understand you don't like to TPR and doing a conventional adoption, but we're not going to go so far as to leave these kids in a guardianship. You have this middle option of TCA, and they push that very hard. And that's not good. And that was not the intention of the bill in any way, shape, or form. It's unfortunate that tribes find themselves in that position sometimes. And we'll talk a little bit about what strategies there might be to push back against an effort like that. Okay. Now I want to talk about In Re SMAS. In that case, the father and the mother appealed the court's order of TCA, of tribal customary adoption. And what they said was that their due process rights were violated by a failure of the tribe to consider evidence from them in the development of the tribal customary adoption order. They also argued some other things, but this was kind of the key point that I wanted to talk about. And what the court ultimately affirmed the TCA, but the point that I wanted to take from this one is, okay, we have an appellate court, an issue that went up to the court. It was a published decision. You can go out and see it. I believe it's 2018. But it rose all the way to that level where the parents said, hey, the tribe didn't listen to us in the development of the TCAO. And it's a little bit of a cautionary tale, because what that means is that we've all got to be really, really focused on making sure that we've got a great record that parents have been included in the development of the TCAO. Now, in that case, there was a tremendous amount of information that the parents had a lot of involvement and had a lot of opportunity to participate. And that was great. And I think that's part of why the court upheld the decision of the lower court. But it's a little cautionary tale to just make sure that we're doing all we can to make sure that parents have a lot of opportunity to be involved. So 10 years later, hundreds of TCAs have been done. And I've fielded lots of phone calls from other states that have said, hey, we'd like to do this in our state, and what is it like and how's it gone, and what have been some of the key points that you've learned over the years. One of the efforts that I think is just really great is that in 2019, New Mexico legislature passed a state law that basically was to push their state social services to collaborate with the tribal nations, the tribes, the pueblos, to develop a tribal customary adoption plan and develop policies and procedures that go with that, and make recommendations to the legislature for implementation of TCA in the state of New Mexico. I just thought that was really great, in that what New Mexico has done is said, hey, we need to have this. It's an important tool for us, and we're going to kind of nudge, force maybe, our state to move towards this in a thoughtful way. And I've had the incredible honor of talking to the work group for the state of New Mexico who's working on this, talking to them about tribal customary adoption in California, kind of lessons learned, because certainly I have no problem saying there's some things I wish we had done differently. I'm sure John feels the same way, things that we could have done to make it even stronger, or to make the bill or the law work better. And so I'm excited to see what New Mexico does. Now, here's one downside in California, and I think that, for example, New Mexico, another state that's looking at TCA, would be able to avoid this. We still don't have regulations in California that help us implement tribal customary adoption, and that's very frustrating. It's frustrating for a number of reasons. One, folks like everybody here on this webinar, you don't have a go-to place to help you read, learn, look to, point to when you're dealing with the county, for example, for state court judges to look to help navigate TCA as a very new function. We have the ACL, and quite honestly, it's flawed. That ACL has some information that's not accurate, and it really, I think I get a lot of phone calls and emails, people saying, hey, this is confusing. So if there's anybody from the state of California on this webinar or you're watching, please, 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 we've got to move forward with getting some more supportive guidance for everybody, counties, judges, tribal social workers, state social workers. We've got to do a better job of creating roadmaps so people can utilize TCA in the best possible way. Now, as I mentioned earlier, some tribes have just said, look, TCA is not for us. We still want a guardianship. And some counties oppose guardianships in light of TCA being available. And that is frustrating to me, because the idea of TCA was not to undermine tribes' choices. It was to expand tribes' choices, to give 3 instead of 2 options. Well, technically there's also what we call APLA, or an alternative plan living arrangement for older kids usually. But really the key 2 that we have always focused on, we find ourselves litigating, are conventional adoption with TPR or guardianship. So the idea was to add a culturally appropriate option in the middle. And what we hear sometimes is that counties kind of use the leverage of TCA to push against guardianship, which is frustrating to me. So if there's anybody out there from a county, don't do that, please. Okay, so what do we do when things evolve? And this is really to think about this, 10 years later. So imagining that you did a TCA 7 years ago, and at the time the child was, say, 3 years old, and mom and dad were unable to parent full time, and we had a relative who stepped up. I'm going to use an example of a TCA very loosely, with no names, of course, where grandma was going to be the TCA adoptive parent. And she fully recognized, I think she was in her late 60s at the time, and she and the boys were pretty young, and she recognized that, things are going to evolve. But in the moment, we developed the TCAO, knowing that perhaps in the future, it wouldn't be 100%. But without a crystal ball, it makes it hard. It takes some very careful drafting. What about if you've got a change in the paternity of the biological father? I've had that come up where suddenly it turns out we've got a different biological father who's not a party to the case. What other evolutions might occur? And I want you to just take a minute and think about what other things might change from a child, let's say, that's 3 years old to a child that's 10 years old. What changes in a family? So grandparents get older. More siblings might be born. We might figure out we've got the wrong dad in the case. A child may start to exhibit and might be diagnosed with a developmental disability, for example. Things do evolve. And so folks often say, well, okay, so what do we do about that? What are our options? What are our tools? And unfortunately, there's not a ton of tools, but I'm going to talk about one of the primary tools that we do have. So let's let's talk about when things go really badly. So this isn't just evolution. This is like, whoa, things went really badly, like a pandemic, COVID-19. So what do we do about visitation? Let's say the TCAO includes visitation for a biological parent, and now we can't do it because of COVID. What about the adopting family falls apart late in the process? And that does happen sometimes. The biggest one, the failure by a party to comply with the TCAO. And I am going to use that as our example, return back to the statute and talk about that. Another one that does come up is the death of an adoptive parent or a biological parent. If the biological parent is included in the TCAO for visitation and then passes, what do we do? And then a child that refuses to comply with the TCAO. Let's say there are some elements of the TCAO that involve the child. I worked on a TCAO that involved twins who would have to travel a long distance back to the Midwest of the United States to engage in cultural activities. When we did the TCA, the children were pretty compliant and they were younger. But I imagine when they turned into teens, they might say, no, I'd rather go to soccer camp or basketball camp. I don't want to travel like that. So what happens? So this is the key piece of TCAO, of the TCA process that we built in to allow a TCA to evolve. And it's really about ordering compliance with the TCAO. But I think that it is our tool for addressing evolution when things evolve and also when things go badly. So really both of those slides that we just went through, the idea that a case evolves or the idea that something kind of catastrophic happens, what do we do? So this is 36626E3. That's a reference to the Welfare and Institutions Code. And this is an exact quote from the law. A tribal customary adoption order evidencing that the Indian child has been the subject of a tribal customary adoption shall be afforded full faith and credit and shall have the same force and effect as an order of adoption authorized by this section. What that means is, just breaking it down, that if a kid has been customarily adopted, then that is an order of the California State Court. If we've got to change a California State Court order, we're going to have to go through the California State Court. It can't be done off on the side. It actually has to go back to court. The rights and obligations of the parties as to the matters determined by the Indian child's tribe shall be binding on all parties. So when the tribe says, here's the TCAO, that's it. And it does bind the parties to the TCAO. So that includes the biological parents, even if the biological parents have refused to participate or have been unavailable to participate. I want to be really clear. I mentioned earlier, one of the reasons to do TCA was in part because it didn't require transfer to tribal court. The ability of a biological parent to veto a transfer to tribal court is one of the tools that a biological parent has to kind of thwart tribal jurisdiction. No, it's their right, and that's the federal law. But it's we didn't want TCAs to be able to be thwarted by biological parents. So the law specifically says that the objection of a biological parent to TCA as the permanent plan does not stop TCA. So that's an important difference, I think, just in thinking about the ability of the tribe to move forward with tribal customary adoption as a permanent plan. It does not hinge on the biological parent agreeing. So we've got this binding TCAO. We've got to go back to court if we're going to change it. The court shall not order compliance with the order, absent a finding that the party seeking enforcement participated in or attempted to participate in good faith, some kind of family mediation service, either court or dispute resolution process through the tribe. And what does that mean? So when we were working on this bill, we wanted to be sure that we allow the parties to come together and try to figure out how to resolve issues when a TCA case or a family had evolved or when something bigger and bad had happened. And so, but we didn't want everyone running directly into court. Now, earlier I mentioned visitation as kind of the one that seems to be the sticky wicket in TCAO compliance. So if a parent wants to go into court, wants to get compliance, let's say the adoptive family has stopped allowing the parent, the family of origin, to have contact that was part of the TCAO. So let's say the TCAO says that biological mom gets to see the children. It's something like under certain conditions, and in COVID, it would certainly be under certain conditions. And when she meets those conditions, she can see the children supervised once a month. And let's say the adoptive family disagrees that mom has met the conditions and they refuse to allow the once a month visitation. What's mom to do? Or I'm going to flip it over and say, let's say that the tribe in the TCAO has language that says that the child will be brought to the reservation and allowed to participate in certain activities with extended family 2 times a year. And the adoptive family just refuses to bring them to the reservation. For example, I had a case in which they said they thought it was dangerous to bring the child to the reservation. So what does the tribe do in that situation? Or in the prior one about visitation, what does the parent do? The tribe or the parent, they're the party seeking enforcement. So what do? Well, first they have to exhaust some kind of mediation. So that might be actually formal mediation, hiring a mediator, and getting everybody to mediation. Not always easy, probably providing them some kind of notice, trying to create an opportunity for folks to get together. Now, we left this kind of lowercase m mediation. This is not formal mediation. It can be, and the parties can use court mediation, but we also left it open to some kind of dispute resolution to the tribe. That could be tribal court, by the way, which I think now, as tribal courts expand in California, might be a good option. Now, I'll say 10 years ago, what we imagined was maybe more social services department within the tribe would help bring people together and try to create an opportunity to resolve differences or problems. I actually have not been part of a tribal mediation or a tribal dispute resolution process on a TCA yet. Now, I don't know if that's just by luck or because folks have, in the TCAs that I've done, have had just a better time. We haven't had things that needed that. But that's what that language means. Now, let's say that the tribe is able to bring the parties together. They make a very good faith effort at trying to solve whatever the problem is. The example I gave earlier was that the children were supposed to be brought to the reservation to participate in, say, a gathering and see extended family. The adoptive families refused to do that. Everybody comes together, maybe in a tribal setting, maybe in a formal court mediation setting, and they don't resolve the problem. Then the party, for example, in this case, the tribe, can bring an action in state court for enforcement of the TCAO. The primary method or tool that the state court's going to have for that enforcement is going to be contempt. I want to be clear, the court is not going to undo the tribal customary adoption. The court is not going to say, hey, adoptive family, you've refused to comply with the adoption, the visitation, we're going to take the kid away. That is not going to happen. To undo a TCA completely and remove a child, you're really talking about a brand new child welfare action and kind of starting over. I did do one TCA in which maternal grandma was the adopting parent, and she became quite a bit older, and mom had recovered. She had done what we all hope our families do. She had healed, and it was great. And so she had started helping care for the children as her mother's health had declined. And eventually that mom went back into court, and functionally she adopted her own children back to her. That is really what has to happen. I see a little bit of notes in here, so I'm just going to double check if we've got any chat real quick. Oh, great. Hi, Dorothy. Hi, Maureen. Thanks for being here. Okay. So that is the tool we built in for dealing with problems in a tribal customary adoption when things evolve or devolve, when we hit problems. I want to take a moment and talk a little bit about like a COVID situation. What we've heard is that like, hey, how do we comply with the terms of the TCAO when we've got these limitations because of COVID? Particularly on visitation or attending an event within a tribe or something like that. Are we going to be held in contempt if we don't have in-person visitation with parents? Now, I did do a webinar about actually doing a TCAO in COVID and presented paragraphs that I would intend to build into a TCAO that if I had to do one now, which is during COVID and post-COVID and how you would handle things. But I think that, this is a transient, we hope, fingers crossed, a transient event. And at some point, COVID will be in the rearview mirror. Maybe not entirely, but our ability to be flexible and to say, all right, we've got visitation in here. We never imagined that there would be a pandemic, or, for example, not long ago, we had wildfires in California, that the parties would work that out and figure out a way to live to the spirit of the TCAO and be flexible. Now, I don't want to be Pollyanna-ish. I understand that a lot of times when a family has a child removed, it's a very traumatic event, and it's really hard to be your best self and to be cooperative in some of these cases. I get it. And so if there really is a problem, there is this ability to go back into state court and get guidance and maybe an order so that the problem can be solved. And I think that that's our main component of the TCA statute for problem solving. Now, there is a very limited way to undo a TCA. And I think I'd remiss if I didn't point this out, because earlier I said, they really can't be undone. Like a guardianship that can be undone with a 388 petition, which is quite honestly a relatively simple petition to file. Doesn't mean it's simple to win, but simple to file. We built this in as similar to other types of conventional adoptions. If it turns out that the child has a disability that no one could have been aware of, the TCA can be reversed in the first 5 years. So let's say that the subject of the TCA is an infant, and no one could have known that the infant had a tremendous disability. The adoptive family can essentially undo the TCA within the first 5 years. So you can see that statutory perspective or statutory language right there. Two conditions have to be met. The child has to have had the developmental disability that was not knowable when the TCA was done, and the undoing has to be within 5 years. So if the disability, the developmental disability or mental illness, which was present prior to the TCA, and there's the issue with the child can't be relinquished to a licensed adoption agency because the child is deemed unadoptable, and this could not have been known. Now, I think this is extremely limited. I've never heard of one of these happening. I've never heard of a relinquishment based on this, but I just thought I would be remiss if I didn't point out that there is some language, and this is similar to a conventional adoption in state law. Now, if the facts on this limited undoing prove satisfactory to the court can set aside that tribal customary adoption order, and it has to be within 5 years. And if that was to occur, the biological parents of the child can petition for return of custody, and the tribe has to be consulted on the entry of an order of set aside. So there's a lot going on there. It has to be a disability that couldn't have been known. It has to be within 5 years. The child is deemed unadoptable. It has to go to court. It's not automatic, and the court has to believe and agree with all that information. Biological parents can step back up, and the tribe has to be provided notice that there's a set aside petition. I keep wanting to say, are there any questions? I apologize. If you've got questions, feel free to put them in the chat. Okay, so we're almost done with our time, and I just wanted to say, what might be helpful or appropriate in terms of next steps on some of these issues related to TCAs that continue to evolve and TCAs that hit roadblocks and become extremely difficult. I've given you some examples of the issues that I have seen arise in some of the cases that I have worked on. So what would be helpful? A couple of takeaways that I think that we should all be mindful of. One, thinking about that language and that issue that the court recently in 2018 wrestled with in the In Re AM case, which is making sure that everybody participates in the development of the TCAO, understanding that you can ask someone to come to the table to participate. They may reject. Make sure we've got a really good paper trail showing the attempt at bringing people together so we avoid a due process argument. The other is in the drafting of the TCAO, remember that adorable baby is going to grow up. And so we've got to be sure that the TCAO can be flexible. We can't anticipate a pandemic. That's pretty much impossible. Or whatever the next occurrence is that might be equivalent to a pandemic. But what we need to do is make sure that when we're working on that TCO with that family in that moment, that we think about all those things that kind of naturally occur, like siblings being born. It's possible there could be a different dad. People needing to move. I had a TCA with someone entering the military, which required a move, and yet there was some language in there about not moving. And taking the child farther away from the reservation. We've got to think about all those things. But in the end, if we haven't thought of every possibility, and we've got to come to a way to keep that TCA intact, well, then we know that there's language in the law that allows us to do that. We need to be sure that we make that effort to bring people together. Cannot march straight into court. Have to show that you've attempted in good faith to resolve the issue. That can be either through court mediation, formal private mediation, or even a tribal process. And I start to think that maybe tribal court might be a good method for doing that mediated resolution. Hopefully that's the way that the issue gets resolved, but unfortunately, if it doesn't, then at that point, a party can bring the case back to state court and request assistance in getting compliance with the TCAO. Now, I think that at that time, if a party is going into court trying to get compliance with the TCAO, I haven't had it happen, but I think, especially as we see the evolution of these families and these kids and circumstances changes, and all of our circumstances do change, that we will find that a state court will work with the parties, hopefully, to come up with ways to resolve these barriers of a TCA or within a TCAO. So for example, the parties could agree to amend the TCAO on the issue that is causing the problem. Let's say it's on that visitation issue, and that is not barred by the statute. Now, what you can't do is you can't change it in a way that would be in opposition to the adoption order. You can't just switch out adoptive parents, for example. But I continue to believe that a state court bench officer could hear a resolution from parties and would be able to make an amendment to its prior order as long as it's not in opposition or completely contrary to the final adoption order. So that's kind of the wrap up. Gosh, that went really fast. I really want to thank all of you for being here. I want to thank John for joining us for that, what I found interesting background on just that view of TCA as a tool. And as we move forward with, planning our legislative agenda for the next year, we certainly have our eyes on ways in which we can support TCA, make it more effective, more readily available, hopefully simpler for tribes that choose to utilize it, for families that choose to utilize it. And so we are mindful that there is a need to, number one, continue to push California Department of Social Services to provide necessary guidance, and then also potentially some legislative fixes. If you've got any ideas, we're all ears and really appreciate it. I see a couple more things pop in the chat. Just want to see if there's any questions before we close. Oh, I've got a question of, would it be possible to receive the presentation slides via email? I think absolutely. I'm going to let my wonderful colleague, Season Goodpasture, take care of that. And then Liz, hey Liz, what to do when adoptive parents are brought up on CPS allegations and eventually lose the children? Should the order always name a successor or state that the tribe has that decision-making authority to name one in the event the adoptive parents die? Liz, great question. And when I'm involved in conversations about development of the TCAO and thinking about what do we do beyond the 5 required elements of a TCAO, those ones that we're so aware of, have to articulate if the child is eligible to be an heir from both sides of the family. We have to articulate the child's relationship, political relationship to the tribe, those required. Exactly what you've raised, successor care providers, is for me probably one of the most important. Again, we don't have a crystal ball. But I think it's really important that we name successor care providers when we do a TCAO. That doesn't mean it's going to hold, right? The state court will still have to step in if a care provider passes away, but I think that it gives a good roadmap to the state court if a successor care provider has been named in the TCAO. Now, what about adoptive parents that are brought up on, that have a CPS case open up? Well, they're in the same place, honestly, as biological parents. They're going to have a case, and they would be entitled to go through services. If they're Indian parents, then they would, and the child's eligible for enrollment or is enrolled, and there's an Indian parent, it'd be an ICWA case, you have that same analysis. And then depending on the outcome of services, we would see what happens. But we need to think about TCA as the same as a conventional adoption for purposes of a transition of care providers under a CPS case. And then the next question, Karen Kolb, what if the TCA parent passes away or the parent has gotten better over the years, had a close relationship with the 4 children? It sounds to me, Karen, like you have a certain case in mind, wants to dissolve the TCA and regain parental rights. Any advice? I think we've kind of covered that, Karen, that there are options, but really, if the TCA parent passes away, then there's going to have to be, if there's not a successor care provider that the state court immediately grabs onto, there's going to have to be an adjudication of who's going to care for the children. And dad is in the running just the same as any other extended relative. But dad is not a shoo-in, right? Still has to engage in a court process. And then the last one is Winona Aubrey Herzog. How does that work with AAP funding when an adoptive parent passes? Interesting question. And I have to go back 10 years. So I'm hesitant to answer because my information could be aged. But my understanding is that even when an adoptive parent passes, the child continues to be eligible for AAP until such time as a new legal parent is established. And if the child's, like, say, in that, often 16, 17 age range, when they're probably going to not have another adoptive parent, and they're probably going to remain in a foster care situation, they still are able to keep the AAP funding to, say, a foster parent. That's my understanding, but please don't hold me to it. That's certainly a good question, and you probably prompted me to do a little research and make sure I got the right answer. So I want to thank everybody for participating and for being here today. Really, really appreciate it. And feel free, as always, to reach out with any other questions that you've got. I want to thank John yet again. And everybody, please be safe, take care, and we'll see you soon. Bye-bye.